A lawsuit is a vernacular term for a suit, action, or cause instituted or depending between two private persons in the courts of law. The term refers to any proceeding by a party or parties against another in a court of law. Sometimes, the term lawsuit is in reference to a civil action brought in a court of law in which a plaintiff, a party who claims to have incurred loss as a result of a defendant's actions, demands a legal or equitable remedy. The defendant is required to respond to the plaintiff's complaint. If the plaintiff is successful, judgment is in the plaintiff's favor, and a variety of court orders may be issued to enforce a right, award damages, or impose a temporary or permanent injunction to prevent an act or compel an act. A declaratory judgment may be issued to prevent future legal disputes. A lawsuit may involve dispute resolution of private law issues between individuals, business entities or non-profit organizations. A lawsuit may also enable the state to be treated as if it were a private party in a civil case, as plaintiff or defendant regarding an injury, or may provide the state with a civil cause of action to enforce certain laws. The conduct of a lawsuit is called litigation. The plaintiffs and defendants are called litigants and the attorneys representing them are called litigators. The term litigation may also refer to criminal trial. Rules of procedure and complications. Rules of criminal or civil procedure govern the conduct of a lawsuit in the common law adversarial system of dispute resolution. Procedural rules are constrained and informed by separate statutory laws, case laws, and constitutional provisions that define the rights of the parties to a lawsuit. Though the rules generally reflect this legal context on the face, the details of the procedure differ greatly from jurisdiction to jurisdiction, and often from court to court even within the same jurisdiction. These rules of the particular procedures are very important for litigants to know, because the litigants are the ones who dictate the timing and progression of the lawsuit. Litigants are responsible to obtain the suited result and the timing of reaching this result. Failure to comply with the procedural rules may result in serious limitations that can affect the ability of one to present claims or defenses at any subsequent trial, or even promote the dismissal of the lawsuit altogether. Though the majority of lawsuits are settled before ever reaching a state of trial, they can still be very complicated to litigate. This is particularly true in federal systems, where a federal court may be applying state law, or vice versa. It is also possible for one state to apply the law of another in cases where additionally it may not be clear which level of court actually has jurisdiction over the claim or personal jurisdiction over the defendant, or whether the plaintiff has standing to participate in a lawsuit. About 98% of civil cases in the United States federal courts are resolved without a trial. Domestic courts are also often called upon to apply foreign law, or to act upon foreign defendants, over whom they may not even have the ability to even enforce a judgment if the defendant's assets are theoretically outside their reach. Lawsuits can become additionally complicated as more parties become involved. Within a single lawsuit, there can be any number of claims and defenses between any number of plaintiffs or defendants. Each of these participants can bring any number of cross-claims and counterclaims against each other, and even bring additional parties into the suit on either side after it progresses. In reality, however, courts typically have some power to sever claims and parties into separate actions if it is more efficient to do so. A court can do this if there is not a sufficient overlap of factual issues between the various associates, separating the issues into different lawsuits. The official ruling of a lawsuit can be somewhat misleading because post-ruling outcomes are often not listed on the Internet. For example, in the case of William J. Ralph Jr. v. Lind Waldock and Company, one would assume that Mr. Ralph lost the case when in fact, upon review of the evidence, it is found that Mr. Ralph was correct in his assertion that improper activity took place on the part of Lind Waldock, and Mr. Ralph settled with Lind Waldock. Cases such as this illustrate the need for more comprehensive information than mere internet searches when researching legal decisions. While online searches are appropriate for many legal situations, they are not appropriate for all. Procedure. The following is a generalized description of how a lawsuit may proceed in a common law jurisdiction. Pleading. A lawsuit begins when a complaint or petition is filed with the court. This complaint should explicitly state that one or more plaintiffs seek damages or equitable relief from one or more stated defendants, and also should identify the legal and factual basis for doing so. It is important that the plaintiff selects the proper venue with the proper jurisdiction to bring his lawsuit. The clerk of a court signs or stamps the court seal upon a summons or citation, which is then served by the plaintiff upon the defendant, together with a copy of the complaint. This service notifies the defendants that they are being sued and that they are limited in the amount of time of a reply. The service provides a copy of the complaint in order to notify the defendants of the nature of the claims. Once the defendants are served with the summons and complaint, they are subject to a time limit to file an answer stating their defenses to the plaintiff's claims, which includes any challenges to the court's jurisdiction, and any counterclaims they wish to assert against the plaintiff. In a handful of jurisdictions, a lawsuit begins when one or more plaintiffs properly serve a summons and complaint upon the defendant. In such jurisdictions, nothing must be filed with the court until a dispute develops requiring actual judicial intervention. A complaint can be considered one of the more important steps in pleading during a civil case. This document states the actions that the plaintiff intends to take and also the factual and reasonable basis for the actions. This essentially sets the framework for the entire case and the claim that will be held noteworthy throughout the entire lawsuit. If the defendant chooses to file an answer within the time permitted, the answer must address each of the plaintiff's allegations. The defendant has three choices to make, which include either admitting to the allegation, denying it, or pleading a lack of sufficient information to admit or deny the allegation. Some jurisdictions, like California, still authorize general denials of each and every allegation in the complaint. At the time the defendant files an answer, the defendant also raises all affirmative defenses. The defendant may also assert counterclaims for damages or equitable relief against the plaintiff. For example, in the case of compulsory counterclaims, the defendant must assert some form of counterclaim or risk having the counterclaim barred in any subsequent proceeding. In the case of making a counterclaim, the defendant is making a motion directed towards the plaintiff claiming that she was injured in some way or would like to sue the plaintiff. The plaintiff in this example would then receive some amount of time to make a reply to this counterclaim. The defendant may also file a third-party complaint, which is the defendant's privilege to join another party or parties in the action with the belief that those parties may be liable for some or all of the plaintiff's claimed damages. Filing an answer joins the cause and moves the case into the pre-trial phase. Instead of filing an answer within the time specified in the summons, the defendant can choose to dispute the validity of the complaint by filing a demurrer or one or more pre-answer motions, such as a motion to dismiss. It is important that the motion be filed within the time period specified in the summons for an answer. If all of the above motions are denied by the trial court, and the defendant loses on all appeals from such denials, and finally the defendant must file an answer. Many courts have a pro se clerk to assist people without lawyers. Pre-trial discovery. A pre-trial discovery can be defined as the formal process of exchanging information between the parties about the witnesses and evidence they will present at trial, and allows for the evidence of the trial to be presented to the parties before the initial trial begins. The early stages of the lawsuit may involve initial disclosures of evidence by each party and discovery, which is the structured exchange of evidence and statements between the parties. Discovery is meant to eliminate surprises, clarify what the lawsuit is about, and also to make the parties decide if they should settle or drop frivolous claims or defenses. At this point the parties may also engage in pre-trial motions to exclude or include particular legal or factual issues before trial. There is also the ability of one to make an under-oath statement during the pre-trial, also known as a deposition. The deposition can be used in the trial or just in the pre-trial, but this allows for both parties to be aware of the arguments or claims that are going to be made by the other party in the trial. It is notable that the depositions can be written or oral. At the close of discovery, the parties may either pick the jury and then have a trial by jury, or the case may proceed as a bench trial. A bench trial is only heard by the judge if the parties waive a jury trial, or if the right to a jury trial is not guaranteed for their particular claim or for any lawsuits within their jurisdiction. Trial and judgment. At trial, each person presents witnesses and the evidence collected is recorded. After this occurs, the judge or jury renders their decision. Generally speaking, the plaintiff has the burden of proof in making his claims. However, the defendant may have the burden of proof on other issues, such as affirmative defenses. The attorneys are held responsible in devising a trial strategy that ensures they meet the necessary elements of their case, or to ensure the opponent will not be able to meet his or her burden. There are numerous motions that either party can file throughout the lawsuit to terminate it prematurely, before submission to the judge or jury for final consideration. These motions attempt to persuade the judge, through legal argument and sometimes accompanying evidence, that there is no reasonable way that the other party could legally win, and therefore there is no sense in continuing with the trial. Motions for summary judgment, for example, can usually be brought before, after, or during the actual presentation of the case. Motions can also be brought after the close of a trial to undo a jury verdict contrary to law or against the weight of the evidence, or to convince the judge to change the decision or grant a new trial. Also, at any time during this process, from the filing of the complaint to the final judgment, the plaintiff may withdraw the complaint and end the whole matter, or the defendant may agree to a settlement. If the case settles, the parties might choose to enter into a stipulated judgment with the settlement agreement attached, or the plaintiff may simply file a voluntary dismissal, so that the settlement agreement is never entered into the court record. The decisions that the jury makes are not put into effect until the judge makes a judgment, which is the approval to have this trial information be filed in public records. In a civil case, the judge is allowed at this time to make changes to the verdict that the jury came up with by either adding on or reducing the punishment. In criminal cases the situation is a little different, because in this case the judge does not have the authority to change the jury decision. Appeal. After a final decision has been made, either party or both may appeal from the judgment if they believe there had been a procedural error made by the trial court. It isn't necessarily an automatic appeal after every judgment has been made. However, if there is a legal basis for the appeal, then one has the right to do so. The prevailing party may appeal, for example, if they wanted a larger award than was granted. The appellate court or a higher court then affirms the judgment, declines to hear it, reverses, or vacates and remands. This process would then involve sending the lawsuit back to the lower trial court to address an unresolved issue, or possibly request for a whole new trial. Some lawsuits go up and down the appeals ladder repeatedly before final resolution. It is important to note that an appeal is not a retrial or a new trial. It is essentially based on reviewing errors that were made in the trial or errors in judgment that were possibly made by the jury or judge. Specifically, The initial step in making an appeal consists of the petitioner filing a notice of appeal and then sending in a written document stating reason for appeal, to the court. Decisions of the court can be made immediately after just reading the written brief, or there can also be oral arguments made by both parties involved in the appeal. The appellate court then makes the decision about what errors were made when the law was looked at more closely in the lower court. But there were no errors made, the case would then end. But if the decision was reversed, the appellate court would then send the case back down to the lower court level. There, a new trial will be held and new information taken into account. Some jurisdictions, notably the United States, but prevalent in many other countries, prevent parties from relitigating the facts on appeal, due to a history of unscrupulous lawyers deliberately reserving such issues in order to ambush each other in the appellate courts. The idea is that it is more efficient to force all parties to fully litigate all relevant issues of fact before the trial court. Thus, a party who does not raise an issue of fact at the trial court level generally cannot raise it on appeal. When the lawsuit is finally resolved, or the allotted time to appeal has expired, the matter is res judicata, meaning the plaintiff may not bring another action based on the same claim again. In addition, other parties who later attempt to relitigate a matter already ruled on in a previous lawsuit will be stopped from doing so. Enforcement: this is the time when the judgment made by the court is enforced in the termination of the case and also for future cases. When a final judgment is entered, the plaintiff is usually barred under the doctrine of res judicata from trying to bring the same or similar claim again against that defendant, or from relitigating any of the issues, even under different legal claims or theories. This prevents a new trial of the same case with a different result from becoming a repeat trial that merely multiplies the judgment against the defendant. If the judgment is for the plaintiff, then the defendant must comply under penalty of law with the judgment, which is usually a monetary award. If the defendant fails to pay, the court has various powers to seize any of the defendant's assets located within its jurisdiction, such as writ of execution, bank account garnishment, liens, wage garnishment. If all assets are located elsewhere, the plaintiff must file another suit in the appropriate court to seek enforcement of the other court's previous judgment. This can be a difficult task when crossing from a court in one state or nation to another. However, courts tend to grant each other respect when there is not a clear legal rule to the contrary. A defendant who has no assets in any jurisdiction is said to be judgment-proof. The term is generally a colloquialism to describe an impecunious defendant. Indigent judgment-proof defendants are no longer imprisoned. Debtors' prisons have been outlawed by statute, constitutional amendment, or international human rights treaties in the vast majority of common law jurisdictions. Etymology: during the 18th and 19th centuries, it was common for lawyers to speak of bringing an action at law and a suit in equity. An example of that distinction survives today in the text of the Civil Rights Act of 1871. The fusion of common law and equity in England in the Judicature Acts of 1873 and 1875 led to the collapse of that distinction, so it became possible to speak of a lawsuit in the United States. The Federal Rules of Civil Procedure abolished the distinction between actions at law and suits in equity in federal practice, in favor of a single form referred to as a civil action. In England and Wales, the term claim is far more common. The person initiating proceedings is called the claimant. American terminology is slightly different, in that the term claim refers only to a particular count in a lawsuit. Americans also use claim to describe a demand filed with an insurer or administrative agency. If the claim is denied, then the claimant files a lawsuit with the courts and later participates in the lawsuit. In medieval times, both action and suit had the approximate meaning of some kind of legal proceeding. but an action terminated when a judgment was rendered, while a suit also included the execution of the judgment.